Mr. Steele, Mr. Adams, Mr. Williams, where are we? Ready to go forward? All right. Y'all coming up here to the podium. All right, Sergeant, can you swear in Mr. Williams?
Raise your right hand. You swear affirm testimony you give to the truth, the whole truth, and nothing but the truth. Pronounce your name first and last. You might can't spell first and last.
Jeffrey Williams.
Jeffrey Williams, Jefffery, Williams.
For almost 2 years since we did our jury selection initiation on January 4th, 2023. Mr. Williams has been sitting in a jail since May 9th, 2022. This is 2.5 years waiting for the conclusion of the state's case and a verdict from the jury, and that's why he is tendering this plea. I'm telling the court this, and the court knows when you came out the first time, it's very hard for Mr. Williams. I am not supportive of what we're doing right now. I'm not against it. But I told Mr. Williams, you okay with me saying this?
Yes.
I told Mr. Williams that I think we're winning the trial and we should go to verdict. But he told me I can't wait another 3 months if there is any possibility I could go home because I have children that are hurting. I have things to do, and he has some medical issues that he would like to tend to. He eats out of a bag, Your Honor. He eats processed food only. He gained 75 pounds during trial. He's lost it since. But it is hard. You know, for me, it's only 3 more months. It's enjoyable, actually. I enjoy coming. It's not that enjoyable for Mr. Williams. He told me he wakes up. Can I say this?
Yes.
He wakes up every day, and it's another day in HE blank blank. You're arrested on May 9th of 2022. There were other people in that house with the drugs and the guns. There were people whose the guns are in their names. They were going to come in court and claim the guns. Everybody else was doing as well, but Mr. Williams has entered a guilty plea. I'm not going back on that, but I just want you to know that this case is just wrong to do to somebody with no bond and to hold him hostage. He wants to, you may not do it. He's aware of that. He's aware of that. But the state offered him 15 years on probation. But they keep piling on these conditions. He just said, he made up his mind. He said, I'm just going to go with it. I got to get home. Judge may not let me home, but I'm not doing these conditions and admit that I'm the leader and I'm involved in the killing and my music just promoted everybody to do it. He's not going to do that. So he did not do that. And that's how we wound up here.
All right. Welcome back Inside the Law, everyone. I'm your host, Philip Holloway. Thank you very much for spending part of your weekend with us here Inside the Law. Of course, this is the LawTube channel where we explore the real justice system through the lens of cases that are actually in the news every day. And of course, we've been following very closely the trial in Fulton County, Georgia, that I like to call Fani Willis versus Young Thug. But I don't know if I can call it Fani Willis versus Young Thug anymore because, well, Jeffrey Williams, also known as Young Thug, the Atlanta rapper, or perhaps now maybe the former Atlanta rapper named Young Thug, has entered a plea of guilty. Now, we're going to get into this. We're going to explore it in great detail, but it's important to remember that Williams is not the only individual who has entered a plea of guilty. You know, we, by way of sort of stay here, the week before last was the judge was on the verge of granting a mistrial, Judge Whitaker, because the prosecutors kept on and on and on with one mistake after another, one accident after another. The most recent one, of course, interjecting what's called bad character evidence into the case in violation of the rules of evidence. And of course, that spurred a motion for mistrial. And there was this big discussion. Well, is it going to be a mistrial with prejudice, meaning you can't try anybody again, or would it be a mistrial without prejudice? Well, prosecutors, they get scared of the embarrassment maybe of a mistrial. And so, not surprisingly, the judge's words drove everybody to the bargaining table. And I feel like it was, at least everybody that I know of considered some kind of a plea deal, maybe had meetings set up with Ms. Willis herself to discuss that, because she was the one calling the shots on who got what kind of deal and who didn't. But as we'll see, Young Thug himself got no deal, and he entered what's called a blind or a non-negotiated plea. Well, who else better to help us understand and break down the developments, the breathtaking, shocking developments, than our good friends? Welcome back inside the law to, there she is, Rachel Kaufman. And of course, there's YSL Doug Weinstein. That Doug is one of the few lawyers remaining in the case who, of course, represents Diamante Kendrick. Good afternoon, everybody. How are you guys?
I'm great.
I'm doing great. Good to see you.
Here.
Well, Doug, I know that you've got your jacket and your tie on. You look like you're ready for court today, but I know you've been working because you're still in trial. I want to get to that, Doug, but before I do, I want to take just a minute while you guys are here and we can all sort of talk about it. There's a couple of other videos that I want to show, and here's the first one. This is what the state of Georgia was recommending for a sentence for Young Thug. Take a look.
And Mr. Williams, were you aware of the state's previous offer that was turned down prior to your making this non-negotiated plea?
Yes.
All right. And Your Honor, at this time, the state is making a recommendation of 45 years with 25 to serve in custody, followed by 20 on probation, subject to the special requirements of 1615 for the gang statute.
All right, so there you have it. They were asking for 25 years in prison, and it came out later, and we've got some more video to watch of the actual sentencing, but it came out that, the prosecutors, Doug, were prepared to offer him a deal that would have, on a negotiated basis, let him out. I want you to react to that. But before that, I want you to if you could just take us inside the courtroom, Doug. What was it like when you were there in person watching this plea go down on, I guess it was Thursday?
I think it's fair to say that in 25 plus years of practicing law, I have never seen such a high risk moment in a courtroom. I'm sure like when you're waiting for a jury to come back, it's similar, but the tension was extraordinarily high. I was nervous. I could feel it in my stomach, and it's not my client and it's not me. I cannot imagine what he and his team must have been feeling. If you recall, he came out for the non-negotiated plea initially, and the judge said, "You are here for a non-negotiated plea." And he just sat there. And eventually, after about 30 seconds of silence, she asked if he needed a break to speak to his lawyers, and then spoke to his lawyers in 30 minutes later and came back. And I didn't know if he was going to take the non-negotiated plea when he came back from that 30 minutes. So it's the kind of high drama that has happened, I guess, at times in this case, that when I'm always telling people that court cases are not like you see on TV or in the movies, and yet another moment where you have drama like you see on TV and the movies. So I was really nervous, and the adrenaline was flowing through me. I didn't sleep well that night. I think and I was still feeling it the next day. I don't know about y'all.
It's like whiplash. Yeah. I mean, I can't even imagine for Brian Steele and Keith Adams. You could tell Brian Steele was ready to keep going forward. He really wanted to try the case. He believed in his case. He's been preparing. He hasn't got to present any of his defense. And I know that they've been working hard, as you have been, to, counteract what the state is saying. And he kind of had to, I mean, there's something, it's like whiplash when you're just kind of stopped. It's all over. You go home. It's those files, those boxes of documents that you've been collecting for your trial. And I know for you, it's not over, but for him, it's like, wait, so now what do I do with myself? Hopefully, he's going to, take a bow because of some extraordinary lawyering. And also it's like watching somebody gamble with their life. It's like a really high stakes gambling situation that sometimes you have to take because your client wants you to take it. And it's their choice, not yours. I think if it weren't for the state having offered a time served plea earlier that day and being able to tell the court that that's what the state had offered, I don't think that he would be taking any non-negotiated plea. But I think that signaled to the court what they should do and how disgusting and despicable it was for the state to then, less than 24 hours later that day, go from time served to 25 years in prison, which I don't do math, but like what that would cost the taxpayers to keep that man in prison for 25 years, saying it with a straight face. It just shows how disingenuous they are.
Rachel, we're going to have the actual sentencing. We're going to take a look at that here in a minute or two, but can you help us understand, for those who may be watching now or on replay who may not understand what we talk about? A lot of times we lawyers will speak our language, and we use shorthand for things that oftentimes the public doesn't really understand what it means. Can you sort of help us understand the difference between a negotiated plea and a blind or a non-negotiated plea?
Sure. So whenever you're taking a guilty plea of sorts in front of a judge, you have to be in agreement with the state on the charges to which you're pleading. So you can't be in a murder case and say, well, I want to take a plea to voluntary manslaughter, so I'm going to plead to that. You can't do that. The state has to agree to the charges as to what you're pleading to. Once you've agreed on that, the state can make an offer and you can mutually agree to that and say, let's present it together to the judge as a negotiated plea. Like, 10 do 3 years in prison, and we both agree to it, and we're jointly asking the court to accept it. A non-negotiated plea is much more risky. The state gets to present the recommendation that they've made, and then the defense gets to try to mitigate that with their own kind of evidence and take on the case and ask the judge for something different. Usually, it really depends on the judge. You have to kind of know your judge, but they call it splitting the baby. So quite often a judge will go somewhere pretty close to right directly in between what the defense is asking for and what the state is asking for. And that's kind of what you can expect with a good judge. And so knowing that the state was asking for 25 and that Brian Steele was actually asking for, I think, house arrest, not just time served, she went beneath that. But in a non-negotiated plea, you have to accept whatever the judge sentences you to. So it could be as much or even more than what the state had offered you if the charge allows for it. So it's much more risky. But it also is really hard to take a negotiated plea when the state has all the bargaining power and is offering you 25. And you kind of know that that's inappropriate. So that's why they went non-negotiated in this case.
Well, I don't know about you, Doug, but I've seen situations. I've been involved in situations where, you couldn't reach a plea deal, and so, you go ahead and that maybe you don't want to go to trial or your client doesn't for whatever reason. So you literally throw yourself on the mercy of the court, like Rachel just described, and when prosecutors play this game sometimes, and I think it really stinks when, they're offering you something. Let's just say they're offering you, straight probation or 1 year in jail on a negotiated plea. But then and they say, well, if you want to go non-negotiated, we're going to recommend 5 years in prison. And then you get in front of the judge for the blind plea and you try to mention that, hey, judge, even though they're recommending 5 today, 10 minutes ago out in the hallway, they were recommending straight probation. Judges sometimes shut you down and don't want to hear that.
They don't want to hear it. And this judge, I think, was brilliant, because this judge forced Miss Love to put on the record what her plea offer was. So the public knows that the judge's sentence is for probation. That's the same offer that the state had offered Mr. Williams. So the judge certainly should not take heat from any people, because she didn't sentence him to any less than what the state themselves were offering. And talk about your trial tax. Yeah. Here's the situation. Because he refuses certain to lie about certain things that they want him to lie about, because he refuses certain incredibly unreasonable special conditions. Okay, you refuse that. Watch what we're going to do to you when we go in that non-negotiated. Now we're going to say we want 25 years. Yeah, we said probation before, but now we're going to say 25 years. And the courage, I would say, of Mr. Williams, the faith in his lawyer, the faith in the judge to go in there and bet your life, bet your freedom on your lawyer's ability to argue and the judge's sense of justice is a tremendous, I would say, not a leap of faith in Brian, because he's going to do an amazing job. And you've seen the judge and you have some trust, but it's a leap of faith. And I can totally understand Mr. Williams reconsidering, having to think about it some more, and then presumably go with his gut and say, I trust my lawyer, I trust the judge. This is what I'm going to do. So he's home now, which is the right outcome.
Well, in a minute, Rachel is going to help bring us up to speed on everybody else who took plea deals in the case. If she thinks she can do that, I think she might be able to. But Doug, so I know that you and Max are the two defense lawyers, right? The only two that are still left in trial. Is that correct?
That's correct.
Now, you posted something on social media the other day, and I don't have it handy to share, but you mentioned, I think it was on X, that you sat and waited in Fani Willis's office because there was some kind of discussions maybe that were going to be had in this vein of maybe working this thing out with some kind of negotiation, but she never showed up. Is that right?
Yeah, she essentially, through her people, said, I will meet you tomorrow morning at 8:30 in my office. It kind of felt like a bit of a command performance, but she is the elected DA of Fulton County. So obviously I have respect for that office. So the DA says that she wants to see me at 8:30 to talk about our client. I'm going to be there at 8:30 to talk about our client. And yes, I sat there. She kept me cooling my heels for 30 minutes. She had done that previously a couple of weeks before and had me wait an hour. It's a negotiating tactic that I think is kind of ineffective and old school, but whatever. So yeah, I wait a half hour, am escorted back to the room, and I am greeted by the visage of Adrian Love and Simone Hilton and Adam Abate. And I think Simone and Adam are great. I know not everybody agrees with me, but I was certainly not expecting Miss Love to be there, and I was expecting the DA to be there. So I'm not going to go into details about the negotiations, but I know when I set a meeting with someone, I generally show up for that meeting, or I give some kind of message, some apology and explanation.
Well, when I saw the judge basically asking, I think, and I may be summarizing here, was anybody interested in going and doing a negotiated plea? And I can't imagine, at least not having the discussion with your client. Hey, is this something we want to consider, or do we want to just rule it out? You gotta talk to your client and make sure they are on board with your decisions about that. Yeah. But Fani Willis herself, I think, Doug, was the one that was sort of approving all of the deals that were had in this case. Is that right?
Well, she was the absolute decision maker, at least as far as our deal went. I can't speak to the other defendants, but she was the decision maker. And I know when I have been involved in, this wasn't court ordered, but you could feel like it was court encouraged. And when I have been in those types of mediation situations my whole career, the judge will always insist the decision maker be there, because that is how you reach agreement.
Yes.
And the fact that they did not have the decision maker there lengthened this process, and I think perhaps is one of the reasons we couldn't reach final agreement. I don't know. Was that me?
I don't know.
He just wants attention. Sorry to the listeners. I'm gonna go put her in her crate. She just is an attention seeker like her mother. Let's see.
Okay, Rachel. Anyway, yes, that's what happened there with her not showing up. And you know what? I don't care. I'm not offended, but to me, that's not the way that you handle yourself, and that's not the way you conduct negotiations.
Well, Doug, I don't expect you necessarily to respond to this. Of course, you feel free to, if you want, you certainly can. But if I were representing your client or anybody else that was a defendant in this case, and I had seen the sentencing of Mr. Williams that we saw, where she basically, she let's just say the gamble worked. I want to show the sentencing in just a minute, but I would think that would inspire me to at least have a conversation with my client. Look, do we want to see if we can get that same measure of mercy out of her or not? And come to think of it, this might be a good time. It's about 3, maybe 4 minutes long. I want to go ahead and just play the actual video of the sentencing. And on the other side, I want to go ahead and talk about it. So here we go, folks. Just take a look at the sentencing here.
All right. So it is not lost on the court that the state, had they been able to come to agreement on certain special conditions, was willing to entirely dismiss the RICO count, was willing to entirely dismiss one of the gang counts, and was willing to entirely dismiss this, machine gun count. Was willing to give a sentence that permitted Mr. Williams to walk out of the door today, and therefore does not seem to be particularly worried that Mr. Williams, if on the streets, would be a danger to society. I'm taking that into consideration in crafting my sentence. And in permitting a no-low plea to the RICO count and one of the 2 gang counts, I would not be permitting the no-low to the one if you were not pleading guilty to at least one of them. But you are, and y'all admit a factual basis for the counts that you are pleading guilty to. I find there to be a factual basis for those counts, and for the remaining counts with which you are charged. I am going to impose a sentence, and I've taken a little bit of the suggested special conditions from the defense and a little bit of the special conditions suggested by the prosecution. On count 1, the court sentence is 20 years to serve 5 years, commuted to time served, the balance of 15 years to be probated, and a $25,000 fine. On count 2, the sentence is 5 years to serve, commuted to time served. That's the minimum sentence that's permitted on that count. It is required to be run consecutively. I'm going to run it consecutive to count 1, but I am going to backload. Oh, I'm sorry. That is not commuted. That is 5 years to serve, and it's going to be run consecutively to count 1, backloaded, by which I mean After you serve your 15 years of probation, if you have been successful on that probation, and I sincerely hope that you are, then at the end of that 15 years, I will commute the entire rest of any service portion of your sentence to time served. So I'll get to the end of it and give you the total sentence, but I'm also going to impose a $15,000 fine with regard to that count. Count 57, 20 years to serve 5, commuted to time served, the balance of 15 years probated, concurrent with count 1. Count 58, 10 years to serve 5, commuted to time served, balance probated, concurrent with count 1. 59, 5 years to serve, commuted to time served, concurrent with count 1. 60, 5 years to serve, commuted to time served, concurrent with count 1. Count 61, 5 years to serve, that is required to be also a consecutive sentence, so that's going to be run consecutively to count 56 and backloaded. Count 62, 10 years to serve, also required to be served consecutively, that's going to be consecutive to count 61, also backloaded. So essentially, the total sentence is 40 years to serve the first 5 years in prison, but commuted to the time that you have already served, followed by 15 years on probation, followed then by the backloaded 20 years, which can be served in custody and will be served in custody if you are not successful on your probation. If you are successful in completing your 15 years probation, that will be commuted to time served.
All right. So I think it's worth pointing out for anybody who didn't catch all that, and I'm going to ask you guys to help us make sure we don't miss anything. He's got to complete probation for 15 years, and probation is like living in a minefield. And if you violate any condition or any term, or have any new arrests or anything, not only can they violate you or take away that probation, like we've seen a probation revocation already in this case, but she just put this giant hammer over his head, like it's hanging over his head. 20 more years to serve in prison that he's going to serve if he is not successful on probation. So, she let him out on time served, but she also has crafted a sentence that is potentially very, very dangerous, and one that I might not be all that comfortable with, depending on the client, having to make sure they don't run afoul of any part of that sentence for 15 long years, guys.
I'll take it all day. Compared to being in custody and risking my life. I don't, nobody wants to be on probation for 15 years, but as the judge instructed, he's not going to be able to live in the metro Atlanta area. There were some special conditions that I think that she set up that seem harsh, but they also are going to prevent further issue that I think would come about as just the result of him living the life. It's hard for somebody to leave incarceration and then go home and then be expected to behave. He's going to change his environment. He doesn't have to be on probation in Georgia, which is a beautiful thing. Although she said that he can't use, illicit drugs or whatever. He can go get a prescription for cannabis in California and live peacefully in Los Angeles, where the police and the detectives and the rest of the world, isn't really interested in watching him screw up. Whereas in Atlanta, there's just too many people that I think are out here wanting him to fail. So yeah, 15 years on probation kind of sucks, but what does that really mean for him? I mean, I think it's like a stick that's behind you that they don't have to use. I actually don't think it's going to be that hard for him. I think he's going to be.
Gigi, and thanks for the super chat, Gigi. The comment here is that YSL Steele, Brian, referring to Brian, has a master plan. Well, I don't know, but I would suspect, and look, if I were Brian Steele, I might have in my mind, look, we're going to be back here in 3, 4, 5 years to file a motion to early terminate probation. If my client's in full compliance, maybe I come back and I ask the judge to to amend the sentence and sort of early terminate probation down the line. That's always something that could possibly be done. Doug, what are your thoughts on the sentence that we just watched? I mean, do you think it was a good outcome? I know that you're glad that he's home, but what do you think about the overall architecture of that sentence?
It's not my life.
Yeah.
I guess I'm kind of with what Brian Steele said to the court. We're winning this case. I think it's zero doubt that Brian was winning it for Jeffrey Williams. And I have every confidence if it would have gone to a jury that it would have been not guilties across the board for Jeffrey, especially given that he is not guilty and that he has an amazing legal team behind him. But by the same token, I do understand taking that plea so that he can walk out. And I don't begrudge him that or criticize him for that at all. And I'm kind of with Rachel. I think moving out of Atlanta, getting in this different environment, California, his studios, touring, I think he's going to be just fine. I think he's going to get through this probation. He's a really good person. Getting caught up in this, a lot of that is from trying to bring folks from Cleveland Avenue out of that environment and up with him. And I think that's one of the things that made him such a target for law enforcement. Not that he did good acts, but that he didn't leave these people behind. And now he really doesn't have a lot of choice but to leave a lot of them behind. And I'm sure that hurts him a little bit. But I think he's going to be okay. So while it felt these are tough conditions, some of them, I think he can live with them. And I really think Jeffrey Williams is going to make it through this okay.
Yeah.
He might end up on the other side. We know that, like Snoop Dogg beat a murder case. Someone mentioned that on Twitter and or X, whatever, and I retweeted it. I mean, I think that Jeffrey Williams has the ability to really even go more mainstream and to do amazing things for Atlanta, even from afar, and just for the rap industry and for anti-gun campaigns. I mean, he's a good, I agree with you, Doug. I mean, I think he's a great guy who under different circumstances can really focus on the change that he is capable of making. It really, listening to Judge Whitaker talk to him about rap and about, the meaning behind his words and the power that he has. I do not know Judge Whitaker's children, but all I could think to myself was that she must have kids that are fans, because I really felt like she personally had received from somebody that she loved just the opinion that there are redeeming qualities about this kid and that his reach is beyond Cleveland Avenue.
Yeah.
And that not all of the lyrics are bad. I mean, a lot of what he says is not bad at all. And I'm glad that Brian Steele brought that up. I was amazed, honestly. I would have never guessed that this judge would have done that. And I can't help but just feel really happy with the outcome, given what I expected.
Yeah. I mean, I hope folks stop bashing Judge Whitaker. No judge is going to always rule in favor of your motions. All you can ask for is that they consider everything. And so that if they do rule against you, at least it's after it's well-reasoned and they've considered your point of view. And she has always done that. So was I surprised that she made that ruling? Not particularly as far as the sentence. I wasn't surprised. That doesn't mean I was not a nervous wreck.
Yeah, oh my God.
As soon as I heard her force Adrian Love to put the offer on the table, I could just feel the tension flowing out of my body, because I'm like, okay, I have a pretty good feeling about what is going to happen now.
Yeah.
And I am thrilled that this sentence allows Jeffrey to continue to make his music, continue to have social commentary on what he saw growing up. It does not infringe on his First Amendment rights. I'm really happy with this sentence for him. What I care about really doesn't matter, but I'm a strong advocate for the First Amendment and for people to be able to write these lyrics. No matter what I think of some of the music, sometimes they have the right to do this, and he's going to be able to continue to do that. And I love that. I love that.
Really quick, I just want to go back to something that I had talked about earlier about negotiated versus non-negotiated pleas. And I guess I'm guessing that Doug, that both you and Max Shard's clients, they're charged with things that we didn't talk about earlier, have mandatory minimums attached to them. Okay, so part of the issue of why there's not deals on the table that Doug's client or that Max Shard's client can take, that Shannon Stillwell or DeMontre Kendrick can take right now, are because the state isn't willing to come off of certain charges that have mandatory minimums of like 30 years or life in prison. So you can't go non-negotiated in that case until they come off certain charges. And so that's kind of where the I know you probably can't talk about it, but that's where the negotiations are right now, is that if the state's not willing to come off of those, then they can't take a plea to anything because the judge's hands are going to be tied as to what she's able to do.
That's exactly right. I'm glad you spoke to that. I can't really get into it, but Rachel, you know the implications of, they've labeled my client a recidivist. They've charged him with murder. You tell people if I could do a non-negotiated in that circumstance. They're charging him with a gun.
Well, let me speak to that. Because that's an excellent point. So there are, just to reiterate what Doug and Rachel have said, there are things that the judge simply cannot do. She doesn't have the power to change the charge. She doesn't have the power to just dismiss the charge, at least in this context. I mean, she could do a directed verdict, but we're not there yet. In theory, she could, but we're not there yet. So she can't do anything with it. And when the prosecutor seeks punishment as a recidivist under Georgia law, that's a sentence enhancement. It's kind of like the 3 strikes and you're outlaw, but it's a little bit more complicated. But for our purposes, that's what we're talking about. The prosecutor, and only the prosecutor, can withdraw that recidivist treatment notification and therefore untie the judge's hands. And for murder, there's only one. There's essentially the minimum you're going to get is a life sentence in Georgia for murder. Yeah. So from Doug's perspective, unless the prosecutor comes off some of these things or all of those things and unties the judge's hands, and now they've got no incentive to do it after seeing what happened to them last week. That's why Doug is still on trial.
I mean, they might have some incentive, but again, the state, there's something about just the way that even just the press release from Fani Willis's office, the way that they kind of flipped it around, that they got all these individuals to admit guilt. I mean, it's just amazing the spin that you could put on this. It's like you lost on the big stage, and for you to pretend that this was somehow a win for you, what a warped world you're living in.
But you know what? I mean, give me the right deal, and
you'll take it.
And I'd have to consider that. And if they want to declare victory and go home, that's okay with me. I mean, I'll do my own thing with it, but
exactly. But they're putting you, they're kind of trying to hold on as tight as they can to any power that they have left to save face, even though it's, in my opinion, they've lost all credibility at this point, and that the jurors, even though there's just going to be 2 attorneys or a team of attorneys for each of these 2 defendants left in the courtroom. I mean, where did Young Thug go? Where did Nichols go? Where did Huey go? Where are these guys? And the jurors are just kind of going to be told not to consider it, but it's everywhere. It's breaking news if you just click on your news app on your phone. Mm-hmm. So they know that these guys are going home. And I think that's going to positively impact the case for your client, Doug.
Well, Kamina had asked an interesting question. Is a mistrial still on the table? And so I don't know if there's a pending motion that has not been, because there's only 2 of y'all left, right? So, I mean, anybody that made a motion that subsequently entered a plea of some kind, I guess that would be moot. But Doug, is there any mistrial still a motion still on the table?
That motion that was made for a mistrial by Nicole Westmoreland on behalf of her client, Mr. Nichols, is not moot because under what we call the Harvey rule in this case, any motion made by one defendant is adopted by all defendants. So, excuse me, that motion for mistrial is still on the table. So we'll see what happens tomorrow morning. I believe the reason this case went into recess is because the judge indicated she would not grant it with prejudice, but she wanted to know if we wanted it without prejudice. At this point, we do not want it without prejudice, but I really think she should reconsider the with prejudice because, after 50 mistakes,
Enough already.
I know.
In the words of Joan Rivers, enough already. That's
Well,
what she
yeah.
would say.
I mean, you heard me tell the judge after the last one, I guess the mistrial motion before this one, that she couldn't fix it. Well, she thought she could. So
And she also, at the end of Friday, she was talking about basically having the state put on the record the offers for your client and for Stillwell. And the state was talking about how they withdrew them. And she said, well, you never even put him on the record. So how could you do that? Her level of frustration with them is so obvious at this point, and they just are trying. It's like they're not trying to please her, and they're not reading the room. And so again, they're going to take the risk. If let's just say you don't want a mistrial without prejudice, and you decide to go forward, they better try this case, the rest of this case, as squeaky clean as they possibly can, which I think is impossible for them, because she is not having it. And if it's we've wasted all this time, all this taxpayer money. We've got jurors confused. They've screwed up the case. If it goes ever up on appeal, it's coming back anyways. She knows that. And so,
Well, it sounds like we got some more litigation, some motion litigation, perhaps in the offing and in coming days. So we'll all be very interested to see how that plays out this week. Doug, but Simply HR asked the question that you can see on the screen there. As y'all were congratulating Jeffrey, tell us about how that was, I guess, for you in that moment. And were y'all surprised that he took the plea deal?
I won't. Of course,
Sorry, it's not a deal. I shouldn't say plea deal. There was no deal.
Yeah, I obviously I won't go into the specific things that I said to Jeffrey. It's what most people would imagine. I am just, I didn't know it caught any of me going up to Jeffrey, but I'm just really, really happy for him that he got to go home to his family. Was I surprised that he took a non-negotiated plea? I guess just because of the amount of courage it took in that situation and the fact that he could have taken the negotiated plea. I just admire him even more, is all I can say, with that decision that he did. He turned out he did the right thing. He did something.
What he said in open court, just from the bottom of his heart, it's just exactly who he is.
He is just, I know, I just can't, he is just the nicest guy.
I agree.
He's just a nice, and that's, I guess, what got him caught up in this case to some degree, is being the nicest guy. So, I mean, I guess I'm still smiling thinking about it. And what was that about the plea? I get surprised he took the plea. I don't know. It was just, the last week has been so stressful. I don't know. There's moments where I thought he would take a plea, moments where I thought he wouldn't. Everything's been so back and forth all week.
I still can't believe that the state was willing to offer him a probated time served sentence. To me, that is probably the more shocking than him taking the plea, is the fact that they put that on the table after going after him for all this time. No bond, no nothing.
Yeah.
And
well, Rachel, what does that tell you about how they viewed their case thus far?
Well, they know that they're losing, but they kind of don't care. The fact that they would still ask a judge to give 25 years to him, knowing that anything other than time served would have been more time for him to spend in prison, knowing that they also thought that he was able to get out on probation and be a functioning member of society. Shame on you.
But look at what they also got by him pleading out. They got the removal and I'm not telling them anything they don't know by saying this on the air, so nobody bash me, but they know this. They got the removal of Brian Steele. They got the removal of Keith Adams, and the tremendous resources that those guys, all the people working behind them, all the resources of Mr. Williams, their expert witnesses, the money to fly in record executives to testify. They got rid of, again, they got rid of a lot of resources aligned against them.
That's what they're hoping for. I would guess that Jeffrey's team is going to stay on the team to the extent that they're able to, and help you guys as much as they. I know Brian. Obviously, Brian Steele is like one of the most generous. I mean, he'll be texting you whatever case law you need. And I don't know if some of those experts, I don't know if they've already been paid, but I'm sure that they're not going to take away experts that could help Shannon Stillwell and DeMonte Kendrick.
Yeah.
I think that they're going to stick around. But yeah, that's what they think that they're doing. But do not underestimate Doug Weinstein.
Well, don't underestimate. I mean, I'm not going to speak about what's going on behind, but obviously it's very important for us to demonstrate to the state over the next week or two that while you've taken away members of our team, tremendously important members of our team, we're still going to do a good job.
Formidable, and they don't know who they're effing with is kind of my thing. Like, good luck to them.
I mean, we have to show that. We have to show that.
Well, that's going to be no problem for you, is what I mean.
Yeah. Well,
I've got a question sent to me.
Mhm.
Got a question says, ask Doug, what can we, I guess the public, do to support the remaining men? This is Hallie, by the way. Thanks,
Yeah.
Hallie. Hallie says, I don't want them to get down. Some of us are rooting for them till the very end, and Hallie wants them to know that.
Yeah, I think that I guess my main concern that I addressed on social media at the end of last week is a drop off in support for the guys, for the public viewing of this case. That is a very important morale booster for us, for our clients, to see the stream on Law and Crime, to know that people are supporting Mr. Kendrick and Mr. Stillwell. And I just want continued support. And as long as a light shines on this case, we're in good shape. And so I just want folks to just keep doing what you've been doing. Obviously, interest is going to drop off, especially from the mainstream media. But if everybody else just keeps an eye on this stuff, that's the biggest thing y'all can do.
Well, Rachel, we're going to come back and talk more. I'm sure people have more questions about Mr. Williams and the plea. But do you feel like helping us get up to speed and talk about the other plea deals that were had? Because there were actually negotiated pleas entered by several others, right?
Sure. Yeah. So there were 3 pleas that happened before Jeffrey took his plea. And there's actually pleas that happened pre-trial that I guess I could talk about those, but I think it's probably most important just to talk about the 3 co-defendants. So it was Bruce Harvey's client. And he had a murder count dismissed against him, which allowed for negotiations to get down to, I think he took a 20 years to serve 7 years with credit for, I think, about the 2 years he served. So he's looking at, another 4 or 5 years in prison maximum. And that's sweet. That's how it all kind of started. The chips started falling. And then we had, was it Mr. Ryan, who, is that his name? Rodelius Ryan,
Yes.
who is serving a life sentence. So they commuted his 10-year sentence to time served, because I guess he's been in custody. He doesn't look like he could even be old enough to have served 10 years. He looks like a child. But so his sentence was commuted to time served. And then Huey, who's represented by Mr. Matthews, and I guess there's 2 Mr. Matthews because his son is also an attorney now, which is wild. I think he got 25 due 9, but it's really like 20 due 9, and then 5 years was suspended on the back end. So they're all under 10-year sentences for 3 of the co-defendants that the state spent all this time and all this money trying to show us that they were violent gang, dangerous bad guys. So that's how it kind of, and then apparently young thug Jeffrey, after that they're offering him 15 years probation if they could basically have him set up the case against Stillwell and Kendrick by saying that he actually admits to being the leader of the gang, such that they basically think that they've won the gang count. So
he actually pleaded no contest to being the leader.
Mm-hmm.
Yeah. So how does that work? Tell us what a no contest plea is, Doug.
That's essentially just saying that due to the evidence that's weighing against you, you're not going to fight that. And even though you may be innocent, you think a jury is going to convict or could convict. So it's in your interest to just go ahead and plead to that count, but you're not admitting any actual guilt for it, or liability, by the way.
The state attempted to get up and say, well, we're not okay with that, judge. And the judge is like, well, I'm accepting it anyways, Miss Love.
Yeah. I think the judge is a little bit over Miss Love. And you also saw, by the way, Phil, I don't know if you're going to play this. I'm sure Rachel saw it. They tried to keep his $8 million in jewelry as part of this sentence.
You're right. And I don't have that video, but I wish I did. But you're right.
Well, they took $8 million. Actually took more than that. That'll come out later. They took $8 million in jewelry from him. That's $8 million of inventoried jewelry. And of course, they have a corresponding civil forfeiture suit.
A proceeding for those exact things. Yes.
For those exact things. And what they tried to do was bypass the civil forfeiture and just have the judge take it.
Steal it.
And the judge was having none of it.
Yeah, she's like, isn't there's a civil proceeding going on? And luckily, in my experience, the head of the forfeiture unit in Fulton County has been much more decent, than Miss Love. So like, he's not trying. I mean, he still works for Fani Willis, but he seems to be more reasonable in the way that he works with attorneys. And then in this case, Jeffrey Williams didn't make his money from crime, folks. And so therefore he's going to have a basis for how he paid legally for the things that he bought and that were seized, to take those things and then make them the state's, and then to try to bypass the actual proceeding for it.
Yeah, they're not going to get the bling. They're not going to get it because they have to tie it to, as you mentioned, Rachel, they got to tie it to the commission of some kind of crime. Yeah. But I want to talk just a minute about, the conditions of probation. Okay. So is he banned from Atlanta, or is he not banned, or kind of halfway, sort of sometimes banned from Atlanta? And how does that work?
He's pretty banned. I mean, he can cut for 10 years, right? He has to stay out of the Atlanta MSA.
Weren't there some exceptions though? What didn't she allow?
He can come back for, he can come back for funerals, weddings, graduation, and then Brian Steele got her to add, like, if there's a medical crisis. And then I believe, go ahead, Rachel.
I love this, because this is what I've been saying since the beginning. He needs to come back and do, I think, quarterly anti-gang, anti-gun, some kind of either like assembly at a school, benefit concerts for at-risk youth. I've been saying this the whole time. They could use Jeffrey Williams to curb gun violence in Atlanta. He would go for it. He's going to be the greatest thing that could happen for it. So the fact that he has to do that makes me very, very happy. And he has to do that in Atlanta. So he'll be coming back at least quarterly. Yeah.
So he's got, let's just say, I don't think, if I were him, I would want to get the hell out of Atlanta. Personally, he's got other places he can live, clearly, but to be banished or banned, if you whatever, from the city, but you're still allowed to come back, a reasonable amount. I mean, that seems to me to be something that's be very manageable from his perspective. But does he get to come back to court if they have a proceeding related to that asset forfeiture that we talked about? I mean, that's going to be coming up. I guess it's assigned to a different judge, but he's got a right to come to court to protect his bling, doesn't he?
I wouldn't want to come. I'd be like, I'm not going through security. I'm not showing up anywhere in the Fulton County courthouse. He's probably scarred for life. I was thinking he would show up to, maybe see his friends, but then at the same time, like, I'm getting out of here and I never want to see any of you again. But then again, it would be kind of cool to come back on the other side, free as a bird, and, shake some hands with some of the deputies that would lead him in handcuffs every day.
I mean, Fulton County has been targeting him for years. So if I were him, I would just pick up, get out personally. I haven't spoken to him about this. This is no inside information, but I would be more than happy to get out of Fulton County. If it means bringing my family with me out of Fulton, I would just lock, stock, and barrel, pick them all up, move them somewhere else. I mean, that's what I would do. But whatever.
I want to take just a minute to acknowledge the 1,930 people that I can see watching this live. Thank you all very much for joining us. If you haven't subscribed to the channel, please do so. This is where we bring you inside the real justice system. And we hope to learn how it really works by exploring the cases that are actually in the news. So if you haven't subscribed, please do so. And also please like this video. It helps other people to find the channel. And I want to just say thanks to the folks. We got a lot of great questions and the super chats coming in. Here's one that caught my eye a few minutes ago. I was waiting for the right time to bring it up, but other people are asking similar questions. So is this one that someone asked me about the other night as well? Are defendants who plead out, are they allowed to make a song or write a book about their experience, or is that barred by laws about not profiting from a crime? So their experience, my answer is this. I think they can make whatever music or write any kind of books. Maybe they should write a book about their experience going through this trial. I don't think that there's any law that would prohibit that unless my colleagues on this panel know better than I do.
Do we? I mean, I know New York. New York's the first one that started doing the laws on this. I know they had their Son of Sam law, because I believe, now I'm showing my age, but I believe that the serial killer who terrorized New York during one very hot summer, Son of Sam, believed that he's the one. Now you're really taxing my memory, but he wrote a book and profited off of it, and they passed a law up in New York State after that. That I don't believe it bars you from writing the book. Of course, that would be a First Amendment issue, but it takes all the profits from that. As far as I know, Georgia doesn't have a similar law.
I don't know of any law. I mean, I guess maybe if they owed restitution to any kind of victim, possibly it would go to that. But that's not the situation here. So,
yeah, I don't think there's, and I wouldn't be surprised. Doug, maybe you should write a book about this, huh?
He's going to write a TV show with Mike Judge. Come on.
Yeah, the problem with my writing a book about it is my restrictions on sharing attorney-client confidential information. I guess I could do it.
You get a waiver.
You could co-write it together.
There you go.
Yeah, they just have their voices heard.
Yeah, I don't know that. I don't know. I don't think people are that interested, but
you might be surprised. Pop. Am I saying it? Pop
tart?
No. Yeah, I'm not wearing my glass. Okay, so can you clarify if Thug can write and perform whatever he wants, no restrictions? Can he perform old music with gang content? Rachel, that's for you.
I don't really see why not. I think he'll be careful. I think hopefully the people around him are going to kind of make sure that he sticks to, stuff that wouldn't get him in trouble. I didn't hear any real restriction on him being able to perform. The judge even said, I'm not taking his passport. So any country that will allow a convicted felon, have him.
Did you guys see his tweets today?
No.
I saw it. Yeah.
He's back on the Twitter machine. And he tweeted out, hold on a second, I'm going to tell you this because this is my understanding.
We're talking about Thug?
Thug, yeah, Jeffrey. He tweeted out, hold on just one second, because I want to tell you exactly what it was because I learned a little bit about it. Wait, no, sorry, here we go.
Oh, wait a minute.
He tweeted out earlier this morning. His first tweet was last night, but this morning he tweeted out, wham, let's drop one on these rats, Peter.
I'm going to pull it up, yeah.
He tweeted that 9 hours ago. Apparently, so Wham is little baby, is who Wham is. And then according to my sources outside this trial, nobody involved in this trial, let me make it clear, they say that Jeffrey has been using the term Peter in lieu of slat. So he is being careful about what he says. I mean, I don't know that you're going to see him tweet out slat or say slat anymore.
I feel like Paige Whitaker's kids probably say slat. See, this is the kind of thing, is that it just becomes the meaning has just become something completely different. I'm glad that he's using different words now, and that, you know, we could say Peter means slat, but how are they going to prove that?
Well, Peter is apparently, it doesn't mean slat, but it's in lieu of slat. And
good.
My sources tell me that it's some extension of like pushing P. So.
I mean, yeah, he just needs to keep some people around him. I was talking about this when we were on Nick's podcast the other night, that I just think it's really important that people who become very powerful maintain relationships with people that will say no to them and that will be honest with them about what they need to do to stay on this, you know, the correct path. I think Fani Willis would have benefited from having less yes men around her and more people that were honest with her about how she was handling her power. I think Jeffrey was in a similar position where he was young and didn't have oh my God, I love Kenny Powers. Do you see that? That's hilarious. Okay. But yeah, anyways, I think it's really important that as he goes through these 15 years on probation, that he keeps people around him like Brian Steele, people that he trusts.
Yeah.
That can say, do this, don't do this. This is how we can stay out of trouble this way, so that he can be really strategic about how he goes forward.
Yeah. Yeah. And, you know, I don't want to see any, egregious, I don't want to see too much of a dampening of his right to sing and perform songs, but I don't know the full answer to that question.
All right. So, Doug, let's, you know, I don't know what you're in a position to talk about. What do you think we can expect as the trial moves forward for those of you? First off, if you might be lonely, maybe Rachel and I can stop by and say hi. But you know, I mean, what can we expect moving forward? I know that there's probably going to be some additional motion litigation. From the state's perspective, are they going to be are they making their case now? Are they shortening it, or do they still have to call all these witnesses, or maybe will they tailor their evidentiary presentation to whoever's left on trial?
I don't have a good answer for that yet from the state. Conceivably, they could still present all these witnesses on all these acts that are predicate or overt acts to the RICO charge, even though the defendants who were not involved in any of this are gone. Just like they led off their case with trying to bring Tick into an alleged robbery of a house mom from a strip club. That's how they led their case off. And Tick isn't even sitting in that courtroom and actually wasn't even involved in that robbery. So what are they going to do? Are they going to narrow their list? I don't have really the answer. And so we could find ourselves, we being Max and myself, taking on a lot more than we would have been taking on before. We could end up defending a lot of allegations against co-defendants who have pled out. So, for example, there is a stabbing or stabbing of YFN Lucci that they want to bring in. They could still be bringing that in. So Max and I have a huge amount of additional, it's not only that we lost these resources, but we could have a huge amount of additional work thrown at us that was not initially ours to deal with. We have, I'm not going to get a lot of sleep, I think, the next few months. And you know what? Bring it on. That's fine.
Yeah, exactly. Let's go.
What are you going to tell? What is the judge going to tell the jurors about why the courtroom is much emptier?
So as soon as I may drop off pretty soon, because I'm working, I have a lot more stuff to do today. One of which is I'm drafting a proposed jury instruction regarding that. I'm modeling it off. I found well, I didn't find it. Who found it? One of the lawyers on TikTok that I will occasionally be on live with. She found it, but there's a Ninth Circuit jury instruction, model jury instruction for just this situation. So I'm going to use that as a basis, but I'm coming up with a jury instruction for what we propose that she tell the jury. We have a lot of issues to deal with.
Rachel, if you
By the
were
way, it's that same kind of innocuous instruction that Rachel alluded to earlier tonight.
Yeah, I mean, don't make anything of the fact that there are 4 less people in this room, and
Yeah. I
yes,
mean, some variation of that coupled with, you know, the defendants left in the courtroom still they still have a presumption of innocence, you know, blah, blah, blah. So some form of that instruction, I would hope, would be given to the jury.
Well, Doug, I know you've been working all day. I'm happy to let you go. I know you got things to do. I want Rachel, if she can, to stick around just a minute, because we're going to talk about we're going to talk some about Madam DA and how she has spun these plea deals. If that's okay with you, Rachel. Doug,
okay.
Any parting words?
Yeah, I have parting words. I want to and need to thank everybody that has stuck with us throughout this entire trial, and those that are continue to watch and shine a light on what's going on in that courtroom, and continue to provide support to Mr. Kendrick, and Mr. Stillwell isn't my client, but I'm sure Max would say also thanking everyone on behalf of Mr. Stillwell. Okay.
Doug.
Yeah, and thank you, Doug, for your gracious sharing of your time with those of us who have great interest in this. We really appreciate it. A big inside the law round of applause. I want to hear it through my earpiece. Thanks,
there you go,
everybody, for Doug.
Standing up for this.
I feel like rubbing your belly inappropriately now. Okay, I love babies. I love babies.
All right.
Okay,
all right.
see you guys.
Thanks, Doug. All right. There you go.
Okay, I'm back.
All right. Well, I know. Look, he texted like before we started, and he said he's been working all day, and I just, I know he's really, really, really slammed, and I can't imagine, the kind of workload that he must be under and has been under and will continue to be until this case is over. But anyway, moving along, I wanted to switch gears a little bit. Still, okay, so, and I'm not making this is not a discussion about the upcoming election, except to the extent that Ms. Willis herself is up for re-election this coming Tuesday, day after tomorrow, because today is Sunday the 3rd as we're doing this live. And the timing of this certainly is interesting, because even though her prosecution team, in my view, jeopardized their case, in other words, the judge was about to grant a mistrial, and so they totally, dropped the ball, screwed it up, however you want to couch it. And now that forced them to come to the bargaining table with the co-defendants that you were just talking about. And even though they didn't reach a deal with Williams, young thug, he nevertheless could sort of read the tea leaves from the judge, and he knew that now was his opportunity to go ahead and do this plea. Because look, if he had done this at the beginning, he could have done this at any point. There's no way Judge Glanville was going to give him time served. So he was able to read the handwriting on the wall that was put there by the botched efforts of the prosecution team to get this case tried. And so Willis has come out now, and I guess some people are saying, well, it's obviously they're doing this for political reasons. I don't think they're that good. I don't think they're smart enough to be able to time this in a way. But I think because of the way it just happened to fall, she's definitely trying to get some kind of political gain from this. Rachel, she made some kind of a public statement, didn't she? What was that about?
My understanding is that she made a statement about basically congratulating her team for securing convictions against several of these defendants, not really tying in the fact that she's wasted years of taxpayer dollars in this courtroom, kept these guys in jail, basically held them hostage so that they be in a position where they felt the need to come to the table and accept deals, whether they were, guilty or not. She's trying to basically say that her office successfully prosecuted these guys. And that's a very strange take on the amount of time and resources that she's wasted. So I'm not buying it, obviously. I'm like, but this is how she's acted. I mean, this entire time, she in the face of the personal allegations against her with Nathan Wade and all that, she's stuck by, doubled down and stuck by her own belief that they're doing the right thing, even though nothing's getting done.
She's taken a victory lap politically and spinning this. And interesting enough, we had Williams's father, I think, was out asking people to go and vote for her challenger, Courtney Kramer. And so this whole thing is obviously she's getting a lot of criticism from some interesting places. The music industry is criticizing her because she's using rap lyrics as evidence in a criminal case, as alleged evidence. And so, she really has come under fire. And I think just today, it's out in the local media here in Atlanta. A lot of people are questioning whether or not it was right to use the racketeering or the RICO statute in the way that she's used it here so vigorously and broadly.
It's not the only party that she's using RICO against.
No, and it doesn't take much. RICO is like, I like to think of it, it's like this wagon wheel, and you got the center, which would be the object of some alleged conspiracy, and then you got the spokes going out, and where the spokes come to at the end of the circle is, if that's a person out there, these are all the alleged racketeers, the co-conspirators, and they don't even have to know each other. Normally if you enter into a conspiracy with somebody, you know them, right? Because you've talked about the conspiracy, you've done something to form this criminal agreement. But under the racketeering laws, they don't even have to know each other or know that they're part of the same conspiracy. And it's just crazy. And so she's using this as a, it's a powerful tool. A lot of people say, well, RICO is a powerful tool. It's what brought down the mobs in New York back in, the mob crackdown or mafia crackdown. I guess it was the 80s. And, but now it's so powerful that it can be, and I think arguably has been abused, as what we've seen in this case. It seems very abusive to me.
No, absolutely. And we know that the Georgia RICO statute is actually much broader than the federal statute that was used to take down, organized crime 20, 30 years ago. And the state is, I like to imagine, I have to imagine that they all went to a prosecutor's conference and learned about how to draft a RICO indictment. And they just think that that's the best way to get the most people to plead guilty, because they put people in positions where they feel that they have no other choice. The only difference between this RICO prosecution and Trump's RICO prosecution is that, Fani Willis agreed to bond for most of the I think all the defendants, at least except for one initially, in the Trump RICO prosecution. And then she kept all these guys in custody as long as she possibly could. I think all of it's wrong. And I think, abusing RICO is wrong. And what it ends up with is people, entering pleas and being convicted of things that they may have really had nothing to do with. I kind of am someone who tends to believe that an individual's criminal intent and their actual crime, you should be able to prove the case against them without bringing in so much extraneous information about other people. Keep it simple, stupid. And instead, her office's idea is, let's overcomplicate everything and then hope that the jurors are so confused but dislike these defendants so much that they'll just convict them all, which is incredibly dangerous. And it just shows such a lack of integrity, and it wastes so much time. if you had it like you said you did, you'd be done by now. It's delayed
Well,
justice for everybody.
I know that these jurors would appreciate it if she would keep it simple. But I tell you what I appreciate you, Rachel, and the time that you've spent with us here today. I know that you're eating for two, and it's about that time. So, any parting words from Rachel before we leave it?
No, I'm just excited to see what happens next in this case. I'm really rooting for Doug and Max Shard and their clients, and praying for justice for them. And yeah. And I hope that as when this case ends, we'll be sad in some ways because we want to keep talking about it because it's like local news, but there'll be so many other cases that we can touch on too once it's over. So I'm excited to just kind of see where this channel goes.
We've got the Lake and Riley trial that's about to get underway here in a couple of weeks. We've got the I guess it's the Daniel Penny going on up in New York. Soon enough, we're going to have the Idaho murders. There's always going to be something. Which one of those, or either any of those, or what else might be on your radar that you think would be good?
Well, I mean, I too am quite excited about the Idaho case, mostly because I look at that guy and I'm so curious, curious what's going on with him. I'm excited to see how the Trump litigation plays out, the trying to get Fani off the case, the recusal.
Oh yeah, the Court of Appeals is going to hear argument on that next month in December, and of course we're gonna carry that here inside the law as well. Yeah, so that oral argument on
praying for safety for everybody, but when there is crime, we'll talk about it.
Yeah. All right. Big round of applause and good night, everybody. To Rachel, say thanks, Rachel. All right. Good night, Rachel. And look, I want to say again, thanks to all of you for being here. And we're still going to keep following this case. As you heard Doug say, there's a lot of work that's left to be done. We still have the same prosecutors and the same judge and at least two of the same defendants. And so we're going to keep following this all the way to the end. Just because Jeffrey Williams may not be in the case anymore, this is still something that we have a lot that we can learn from, right? Because that's what we do here inside the law. We try to use these cases to learn how the real justice system works in the real world. But I'm going to have to leave it there for now. Thanks again to all of you. And remember to like and subscribe. And I'll catch you right back here next time inside the law.